there's just something wrong about people growing marijuana in a bedroom where a baby sleeps. At any point, did somebody say, we have young children here, they shouldn't be around marijuana? And I knew it probably stank.
His pleading no contest to child endangerment. But in the very next breath, he insists he had no idea what was happening under his own roof. This is Andrew Ray's a father now staring down years in prison after police uncovered a marijuana grow operation inside a child's bedroom. His lawyer argues he was just unlucky, a victim of selective ignorance, caught in the wrong place at the wrong time. But the judge isn't convinced. She's about to unravel a bizarre living arrangement that leaves him with no way to dodge responsibility. As you hear his testimony, ask yourself, is this a clueless parent blindsided by circumstance or a man pretending not to know, desperate to save himself?
All right, the court is calling 2025 CR 011977 and 2025 CR 007562A, State versus Andrew Thomas Reyes. Can I have parties announced?
Pertaining to the state of Texas. Miguel Hernandez for the defense.
And are you Andrew Thomas Reyes?
Yes.
Counsel, in each cause number, have you received all the discovery and that you review that discovery with your client?
I have, Your Honor, and we have signed a document indicating that we have received all this stuff.
And each cause number, the court will find that the state is in compliance with discovery. Mr. Reyes, in cause number 2025 CR 011977, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure?
Yes.
So why is the judge dragging everyone through all this formality? It's not pointless, it's called lawsuit-proofing the case. By making him acknowledge, on record, that he understands his rights. The court cuts off any chance of him coming back later claiming confusion. It's the first step in locking the case down final, airtight, and untouchable.
Did you understand in that cause number, you have a right to have a grand jury review the evidence and make a decision on whether or not there's enough evidence to hold you over for trial, and also that your attorney has certain rights. Your attorney has the right to have the passage of 2 days once they are presented with the information and 10 days to prepare for trial. Did you understand?
Yes.
Did you understand by entering this plea, you're giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. And each cause number, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes.
All right, off the record, to the clerk. Adriana? Yes, ma'am. I don't have the information in this cause number. Yes, please.
Okay.
It's just the unofficial signed one.
All right.
Unsigned.
And if you can make sure also, Adriana, that you have that.
You're doing the original one with the paperwork.
All right, we'll need to make sure that we have that before things are done. All right. Did you review the felony information with your attorney? Did you understand it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, in each of those, are you waiving the reading?
We are, Your Honor.
State, in the cause number that is the felony information, are you proceeding on that information as presented?
We are, Your Honor.
And the other cause number, are you proceeding on in the indictment as presented?
No, Your Honor, we will waive count 1 of the indictment and proceed on count 2.
No objections, Your Honor.
All right, in each of the cause numbers, did you review the documents entitled Court Admonishments with your attorney? Did you understand them and did you sign them in all the appropriate places?
Yes.
And cause number 2025 CR 007562A. You're charged with possession of a controlled substance, penalty group 2, 4 to 200 grams. I'm sorry, 4 to 400 grams as a second degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison and up to a $10,000 fine. Did you understand?
Yes.
Now the judge is laying it all out, every possible prison sentence, one after another. Think of it like the warning label on a drug commercial. Long, grim, and unavoidable. She's required by law to spell out exactly how bad it gets if he violates probation. It's the court protecting itself so he can never claim. Nobody warned me I could get 20 years for this.
And the felony information, you are charged with endangering a child through criminal negligence as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
If you have plea bargain agreements with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering into these plea bargain agreements, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cases?
Yes.
Counsel, in each cause number, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Reyes, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
I am.
Did you understand by entering into plea bargain agreements in each of these cause numbers, if you're not a U.S. citizen, you will be deported, not allowed re-entry and denied naturalization. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea in the felony information case, punishment is to be assessed at a $1,500 fine. State recommends deferred adjudication. This will run concurrent with 2025 CR 007562A. And the other cause number, the state is proceeding on count 2. There's a $2,000 fine. The state recommends deferred adjudication, and it will run concurrently with the previous case. Did you understand that to be the plea?
Yes.
Defense?
It is.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, in the felony information case, the state is asking that your community supervision be for a term of 2 years. There'll be 100 hours of community service restitution, no contact with Skylar Reyes, parenting classes, TAP evaluation, follow all recommendations in the MRT. In the indicted case, the state is asking that your deferred adjudication be for a term of 3 years. There'll be a TAP evaluation, 200 hours of community service restitution, the parenting classes, and moral recognition therapy. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
You said no, Your Honor. So you understood that? Okay.
Did you understand that?
Yes.
Then, and cause number 2025 CR 007562A to count 2, how do you plead? Guilty, not guilty, or no contest? In 2025 CR 011977, how do you plead?
No contest.
State any evidence.
For both cases, Your Honor, state offers is evidence as Exhibit 1 of all attachments.
We've had a chance to review in both cases, Your Honor, and find no objections.
In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and cite it in both places?
Yes.
Did you understand, again, that you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Rick,
Yes, Your Honor.
if you'll just sign this and they'll file stamp it.
Sure.
Thank you.
You're welcome.
All right, in each cause number, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, my client is taking full responsibility for what occurred in that house and on that evening. Because of that, Your Honor, and because of the fact that he has a clear record, we would ask that that to be taken into consideration. The first thing we'd like to address is that the no contact order, although the state asked for it, we did go through a proceeding with the child custody people, and they found that he has had no problems with his child, so we would ask that he had at worst, no harmful or injurious contact with his child, so that he can see his child.
Why is the lawyer suddenly nitpicking the wording of the no contact order? Because no contact means 0, he wouldn't be able to see his child at all. But no harmful contact? That's the loophole. It lets him still play the role of dad while appearing to face punishment. It's less about grammar and more about strategy, a calculated chess move to protect his client's skin on the family front.